Hi, I'm Debbie Moraes. This is Legal Matters. Welcome. This is a program that's been designed to address the critical and sometimes contentious matters that are facing consumers and businesses today. It's legal information, practical solutions, and straight talk about a wide variety of topics that will affect your home and work life. With us today, flying solo, is our legal counsel from Audette Bazar, Cadero Grasso Law Firm in East Providence, David Bazar.
Hi, Debbie.
Okay, so before the sacred vows of marriage comes the beloved or not so beloved prenup. And we'll talk also a little bit about the rules of engagement or disengagement. So when you think about a wedding proposal, it's a warm, romantic time with promises of a lifetime of love and also binding legal agreements. So before you take a walk down the aisle or take that leap of faith, we thought you might need to know a few of the details that could affect the rest of your life. So David, let's begin with the ring. What a beautiful, beautiful thing that can be. It's a lovely gesture. Who owns it? That's really a legal issue, isn't it?
It sure is. And actually it's pretty interesting because it depends on the facts and circumstances surrounding the gift of the ring. It reminds me a little bit of, as a municipal court judge, I get to do weddings, and one of the things that I say sometimes in the exchange of the rings is a ring freely given, like love, has no giver and no receiver, because both are the givers and both are the receivers.
That's lovely,
yeah,
poetic.
It is, but it has nothing to do with the law. So back to the law, what's interesting about it is, when do you give the ring and on what circumstances? Because a ring given on the idea that it's an engagement ring conditioned upon the marriage is a conditional gift that one might say, I want returned.
If there's not a marriage.
If there's not a marriage. That was the condition of the gift. A gift given on a Valentine's Day, a birthday, or without condition is a gift. And there is no expectation that a condition has to be met for you to keep it. So it's yours once it's given to you.
If you are a skeptical bride-to-be, should you be so unromantic as to ask, is this really mine?
Or to say, thank you for the gift. I really appreciate it. And I would marry you with or without the ring.
Well, that's very nice, too. That's good. Okay, so now the issue about the ring is settled. The couple goes forward.
It's not quite settled.
Never quite settled.
What
right?
happens after to get the ring back is part of that same story. So if we're going to go some lineal fashion on each of these issues, what happens is you give the ring, the marriage doesn't happen. How do you get the ring back?
Court?
We've had cases. We've had cases that have gone to court. And like I said, it turns on those factual issues. One case, the issue was that the bride-to-be, the wife-to-be, gave the ring away, she said. Or maybe she sold it. We're not 100% sure. But she claimed she no longer had it. So what's the remedy in that situation? Well, there it's the value of the ring.
And so how did that get settled? Did she owe him?
She ended up having to pay back the money for the ring because it was clearly an engagement ring given on the condition that, will you marry me? Yes, I will. And you never upheld your end of the bargain.
Okay, so let's keep with that for a second. Does he have to produce the receipt so that she knows how much, or do they have to have, they can't have it appraised, it's not around anymore,
Right.
We don't know if it's appreciated in value. How do you come up with that?
In that particular case, the time frame wasn't so long that a change in value was that relevant, so we went with the receipt from the store as to what he actually paid for it.
Okay, so, now that we've settled the ring issue, the couple goes forward and they start making plans with the banquet hall, the photographer, and of course the wedding dress. If this doesn't go through, the fun stuff, if this doesn't go through, then who owes or owns what?
Okay, so a lot of different issues. All of those issues are contracts. You have a contract with the caterer. There's a contract with the banquet hall, perhaps. There's a contract with the flower person, the florist. There's the contract with the musicians. So deposits are made, and whether or not any of that money gets returned to anybody is probably covered in the contract. Who put out the money and whether or not you're entitled to any contribution between the two parties to the marriage is another issue.
So if he gives a deposit but they jointly sign the contract, then do they have to work out between themselves the deposit being reimbursed or equalized plus whatever they might owe for that obligation to that vendor?
Okay, so in a purely contractual world that we're dealing with in these things, it's very important to know who signed what. If they both signed joint responsibility for the different contracts, and just one of them put up the non-refundable deposits that we'll assume exist in each of these instances, then if the bride, for instance, put up all the deposits, but both of them signed the contracts, she has a claim back for contribution for her loss to the spouse.
That makes sense.
The proposed spouse,
Proposed.
or the putative spouse.
Oh, even better.
Better.
Okay, so going forward, they're not quite down the aisle. The idea of a prenup. Who needs one and why?
Okay.
Just the wealthy?
Not necessarily, but usually. And what is the purpose of a prenup? In our prenups, when we write them, what we say is it's so that we have a tranquil marriage, that we're not worried about what would happen if we didn't stay together. And we want to make sure that all of the possible issues that could become contentious during our marriage are resolved at the beginning. There's a number of different reasons to have a prenup. Many times they're for someone who we see them mostly, where do you see them? California, movie stars and people with a lot of money and this, that, and the other thing. But we also see them in situations where perhaps there's an older person who's a second marriage, maybe a second marriage for both, and they each want to protect their assets for their own children, if they have children prior to this new marriage. So that's one really important instance where you really need to think about that. Sometimes there are cases where one of the two parties getting married is much older, and they want to really have right up front said, okay, I have my own children, I've had these trusts perhaps set up, and I have these issues that I want to just set up with you right up front, including perhaps not only what happens upon dissolution of the marriage, divorce, or death, but what you're entitled to while we're married. I've seen prenups where there's a set expense allowance to the spouse. I'm going to make sure you have $3,000 a month, for example, to spend on whatever you want to spend it on, so that while we're in the marriage, we're not worried about, I'm paying for this, you're paying for that, and what money do you have for your own expenses.
It's supposed to be done in good faith, and it's supposed to be done, I guess, on an even keel, because you want to do this amicably and hopefully without tension, although that's why people don't do it, because it causes tension. If we stay married 3 years, you're entitled to this. If we stay married 6 years, you're entitled to that. Does that speak to something that's negotiated and dealt with in good faith, or is that, do you deal with that, or how would you deal with that?
Okay. All right, and again, we have a lot of issues to cover with prenups.
We do.
But starting with the conditional issues in a prenup, I'm married 5 years, I'm married 10 years, as you laid it out. Those sometimes are important. They're absolutely enforceable. And as long as anything in a prenup is put in is reasonable and both sides understand it, had the right to counsel, and there's full disclosure of all the assets and liabilities going in, all of that's enforceable. Why do we put that in sometimes, I guess, is really what the heart of your question is. And we do that because if one side or the other has a lot of money, and they have children, and there's some concern, we want to make sure that we're not worried about the purpose of going into the marriage, and that someone didn't come into a marriage for a short-term marriage and is then out. I think I saw a movie on this once where this woman was going, she was a serial marrier of rich people, and there were prenups, and in the movie she got in a second, perhaps, marriage, she got her husband to eat the prenup at the wedding reception, or he did, to profess his love for her, if that was really what was going on there. But the point is that there's a good faith intent going into the marriage, and that the longer we're together, the more I'm going to take care of you as part of that thinking.
So that sounds like a reasonable way to deal with it. And what about if you look at money differently as a couple, and your concern might be how you handle debt, and you want protection from debt? How does that work when you want a prenup? Does that keep you apart from your spouse's debts that he incurs against your better judgment or something?
You absolutely, in a prenup, can not only divide up assets, but you can keep your debt and future debts that are incurred during the course of the marriage separate. It's probably as important to people, not only what assets am I keeping if I come out of this thing, so I come out whole, but what debt is going to be mine and what debt's not going to be mine. So we have cases where there's an agreement that if we acquire a marital home together, that's a marital home, and that if there's a mortgage on it, we're going to decide how that should be fairly divided. Whatever debt you incur in your own name during the marriage is going to be your debt. Whatever debt I incur during the marriage is going to be mine. Because typically what we do if there's no prenup is look at what assets and liabilities were incurred during the marriage to determine what that marital pot is for separation upon dissolution.
And if someone goes into the marriage having inherited property, does that remain a non-marital asset that never becomes part of the mix? Does that have to be specified in a prenup? How do you keep those things separate? Do you have to agree on that and write it down too?
Well,
it's an asset.
Of course, anything with divorce depends on where you are living and have jurisdiction at the time of the divorce. So in Rhode Island, if you go into a divorce situation without a prenup, the equitable distribution statute that's in effect at the time of your divorce is going to cover, as it is right now in Rhode Island, it says that property gifted to you or that you receive by way of inheritance is your property. But the inquiry doesn't necessarily stop there, because if you take that property and commingle it with other property that's jointly held, it becomes joint property. If there's an increase in value on some of that property, there is some argument that the increased value might be marital if something was done during the marriage to maintain that asset. So it's important to deal with that in a prenup too. And you absolutely can deal with that by saying anything that I inherit or gifted or that I own prior to the marriage remains my separate property, including any increase in value.
Now, these issues that you bring up are things perhaps that someone might not consider. And I was about to say, gee, we want to inform people how to handle some of their own matters, and do-it-yourself certainly can happen, because on the internet there is a do-it-yourself prenup.com or some other such website that they can download, print, and sign. But what you've indicated suggests at least that there's more to the nuances that might not be listed in a prenup that you'd find online, which is just you list yours and I'll list mine.
Right.
Do you, as a rule, if you deal with someone who's going to do a prenup, go through all of these caveats and all of these other issues that are certainly related?
Yeah, if someone comes to me, we go through all of the different variations of issues that could come into play. And here's the issue I would have with the online prenup. Can you do it? Is it enforceable? Probably, if you do it properly and you follow the rules. But when we do prenups as an attorney on one side, I always tell the other person, because you can only represent one person to a case or it's a conflict of interest, they need to go to an attorney. And the prenup, to me, is much stronger if there's an attestation of an attorney that they read the prenup, went over it with their client, and both parties had an attorneys, and that they're telling their clients that it's fair and reasonable and whatever. I had a case recently where someone had contacted me to represent them in a prenup. She didn't want to change anything. She said right up front, I just want you to sign the clause. And I said, I won't do that. I'm not going to just have you bring in a prenup for me to sign just so that there's an attorney's signature on it saying that we've gone through it and I've represented you. I said, if you don't want to change anything, that's fine, but what I want to do is go through the prenup, tell you what my concerns are with it, put that in writing to you so that there's a memorialization of that we've actually gone through this, and then if you still want to sign it, you'll sign it and I'll sign it with the caveat that I sent you this letter with my concerns, but that it was your free will to sign it. Do it yourself versus having an attorney can do it can lead to a prenup being upheld by a court or not upheld by a court.
Might be not valid, you're saying.
Might not valid.
So if someone wanted to save money, I don't know what it actually would make the difference between, but it certainly might save some time if they took a look at what was online and had an occasion to start to think about and document what their assets and liabilities and what I want to give up. And
Sure.
that could certainly be a nice working document. But it also indicates online that all you'd need to do is fill this out, take it to a lawyer, and he will sign it. And you're pointing out that there's certainly more to it than that if you're doing your due diligence or
Right.
whatever you would refer to that as.
Right. I think any attorney who's going to do this correctly isn't just going to sign what you put in front of them and say, yep, I saw you sign it and you knew what you were doing, and blah, blah, blah. Because to me, your job isn't just to make sure that this is going to stand up. Your job is to make sure your client understands what the rights are that they're giving up, if any, and what issues are involved in the prenup so that you're confident they understand what they are.
David, is there ever a reason why you wouldn't or shouldn't have a prenup? Is there any reason against it?
No, I don't think so. Oftentimes there are things in prenups that I'm not comfortable with, that my clients sometimes are, but I'm okay with it because those things can be changed over time by agreement of the parties. For example, I always like my prenup to say that whatever the provision is on death, that the spouse will execute a will that makes sure that that's covered. But I like it to say that it's not limited to what's in the prenup. The spouse can do more if they want to do that. So there's sometimes I get prenups that don't have that language in it. I'd like to add that. But a prenup can be modified. And
It can be.
It can be, but it has to be agreed to by both parties.
And what kind of circumstance would create an issue where someone would need to update or do this?
Amend or revoke the prenup.
Okay.
If, for example, you've been married for 25 years now, and some of the issues that you had concerns of are gone, you might change the prenup or get rid of the prenup. It's a contract. So to me, a contract can be amended by the parties as long as both parties agree. It can be revoked by the parties as long as both parties agree. And the modifications might represent some significant change that neither party was expecting during the course of their marriage that came into being. What if one of the parties won a multi-million-dollar lottery? What are we going to do there?
Good point. And I suppose the issue that you tossed out a moment ago about something being commingled, the minute someone starts to commingle their funds, does that negate what was originally set up as a prenup unless you update it, as you say?
It depends how the prenup is written. Some prenups are specifically written so that anything I keep in my own name, no matter when it's acquired, even if it's acquired during the marriage, is mine, and what you keep in your name is yours, and anything we want to be divisible is commingled. And what we usually do is say how it's going to be divided upon a death or divorce as a commingled piece of property.
Good to know. And one of the other things that I came across just quickly, and I don't know if you can address this here, but apparently when they say if you're going to put together a prenup, you should list all your assets. If by chance you happen to miss one, exclude one, forgot about it or whatever, that in and of itself could make it null and void because it was either, I don't know if it was intentional or unintentional, I don't know that that's the point, but that suddenly makes or negates the entire prenup. Is that true?
Very possibly, because one of the biggest issues with a prenup is that there's been complete disclosure, that people go into this understanding what their rights are, what they're giving up, and that's why the attorney participation is very important, and that's why complete and accurate disclosure is important. Now, if we're talking about some minimal asset that really wouldn't affect anybody's thinking or reasoning, it's probably not going to be of any impact.
Good to know, too. Another thing that came up as I was taking a look at this and preparing for this is that regardless of the prenup, no prenup covers what might be someone who's older, who needs a nursing home or some sort of continuing care, that there's no protecting the other person's assets. In other words, that was not part of the bargain, that's not part of our contract, that prenup cannot hold that person's assets separate and apart if a nursing home issue comes up.
So if I understand what you're saying,
It's a loophole, is it?
I'm not 100% sure, but if what you're saying is that the prenup is not effective as a way of preserving assets when somebody's going into a nursing home.
Let's go with that.
Okay.
Explain that.
All right. So what the prenup usually does, it says what's mine is mine and what's yours is yours.
Yes.
And so certainly that doesn't give any protection to the husband's assets when he might go into a nursing home if they're not significant enough to pay for the nursing home for the rest of his life, and he's trying to get to the point where he might be entitled to Medicaid to pay
yes.
for it. So if that's the purpose of, if that's the point, a prenup even drafted towards that end may not protect against it because Medicaid may look at the assets and say, no, we don't care what this agreement says, you still have an ability to reach and touch those assets, so you're entitled to use those.
So in this specific reference here, the agreement stated that neither will be responsible for the long-term care costs of the other. That provision will be disregarded if one spouse needs to apply for Medicaid. So as far as the Medicaid is concerned, the assets of the healthy spouse will be considered countable and available to the nursing home spouse for Medicaid eligibility purposes. So I guess that means that there's no specific way to protect your assets. If that were your concern, you must need another instrument or another way of dealing with that, I assume.
Well, what you're looking at there are the rules that apply to Medicaid eligibility. And when you talk about Medicaid eligibility, and I know that's a subject for another show perhaps at some time, but very briefly, they look at your countable assets. And in Rhode Island, what are countable assets? Well, any money you have in the bank, any money you might be getting from a retirement fund or a retirement fund itself, if it's not annuitized, are countable. The house, for example, is not a countable asset. You can own a house because there's always the assumption that you may return to the home someday, so the state doesn't want to force you to sell it to stay in a nursing home when there's the possibility you might return home. And then we have the community spouse, the at-home spouse, and the spouse that's going to be the resident in the nursing home, and what is the at-home spouse allowed to have as opposed to what is in the estate of the spouse in the nursing home. So looking at all those rules, what that paragraph you read is saying is that they're not going to be bound by what's in your prenup. And the mere fact that it says, I'm not going to be responsible for your nursing care, nursing home stay, doesn't necessarily affect the rules as we look at your eligibility for Medicaid.
Okay, good explanation. Next, when you think about, there was a time when people didn't do prenup so often, even though they're spoken about much more frequently now. Wasn't it always the thought that there would be 50-50 division of property, so you wouldn't really have to worry? How would you comment relative to that? You don't really need, maybe you don't need a prenup because it'll all be divided equally and fairly, and we should go forth in faith.
So we're getting married, we're young, we have nothing going in. So everything we're going to have is acquired during the marriage. Perhaps it's 50-50. If you look at the equitable distribution statute, equitable distribution doesn't mean equitable 50-50 necessarily. It means we're going to divide up your assets in accordance with the law at the time of the divorce. And there's a number of factors that go into what equitable distribution is. How was the property acquired? What was each party's role in maintaining the property? What conduct of the party?
No fault?
Well, we have no fault
me?
divorce as a ground, irreconcilable differences, but that doesn't mean conduct is still not a factor in equitable distribution. So irreconcilable differences, we can get divorced just because we don't get along anymore. Equitable distribution, you know, that bad conduct you had and all of the things that you did either wrong or right during the marriage are still counted in how we divide up the assets. So a prenup might take some of that out of play.
When you do a prenup, do you need to have an accountant with you? I mean, not just because someone might have a lot of money, but just because the assets might be more complicated. I don't know, take for example, and I haven't one in specific but in mind, stocks. They change in their value. So would you need to have an actuarial? Would you need to have an accountant say, right now this is worth this much, and as we sign on the dotted line to be married, that's going to be based on that amount and only that amount?
It depends what you're trying to do. Somebody once said recently, math is math, I guess, or something about math in the economy, or arithmetic. But if it's just math, you don't necessarily need an accountant to figure out how to do things. The tax event that might happen is not necessarily the driving force of what you're trying to do. If the tax consequences are a big factor or a driving force of it, then absolutely you want to bring an accountant into that. Just like we would do when we're doing a divorce in determining certain things. Many things in a divorce don't have a tax consequence. Some things do. And sometimes you really need an accountant to really work your way through some of those issues. So if you do have a complex situation of certain assets that will create taxable consequences, then you need to bring them in the prenup just like you would in the divorce.
I suppose to your point too, if someone were just listing on the prenup that they got online.com somewhere and they listed their stocks and its value, if they weren't very savvy about what happens when they sell that or have to divvy it up, that does trigger a tax event that I'm sure that if they didn't know, somewhere a lawyer would be advising them before they decided who deserves how much of what.
Well, yes, and certainly equitable distribution, a division of someone's assets while they're married, is not taxable because we're dividing up what we own. If I'm going to pay you alimony, now we've run into tax consequences for both sides. If we're going to divide up a qualified retirement account by a qualified domestic relations order, that doesn't necessarily create a taxable event. But there are certain kinds of accounts and certain types of things that may create a taxable event. So we need to bear that in mind as we go through either a prenup or a divorce.
And in the short amount of time that we have left, what about those who decide not to be married but cohabit? Do they need something that's not a prenup if they're not going to be married, but do they need a contract to keep that division of assets should they decide to split too?
How about a cohabitation agreement? And now we're really going to get into a whole nother area. But let me say what I find the most intriguing part of people who turn out not to be married when either they think they have a common law marriage or they're just cohabitating and they own property together, especially real estate. I have seen cases, and in researching this, most of the cases on petition to partition cases involve people who got divorced before the equitable distribution statute, and they have to divide up property they own.
That's an interesting topic,
We
too.
can talk about that sometime down the road.
That's a very good, and same thing applies with heterosexual couples as homosexual couples these days.
A cohabitation agreement would still be a cohabitation agreement.
Interesting to know. Well, we thank you for tuning in. I think that we probably touched on a couple of different topics that we'll need to explore a little bit more in depth as we go forward. We certainly hope that you don't have to deal with issues such as divorces, but perhaps this gives you a little bit of insight. We thank you for tuning into Legal Matters. We thank Audette Bazar, Cordero Grasso Law Firm in East Providence, and thank you for watching.